Welcome back to my channel. Today we're going to talk about the status hearing. This is a hearing that is often overlooked or not considered that important by some. It's actually a very important hearing, possibly one of the most important. And today we're going to talk about why that is. The status hearing must occur 60 days after removal. So you're looking at a couple of weeks, few weeks after the adversary hearing, depending on when it actually got heard. This is very important because the status hearing is technically, I guess, the start line of the case. And by that I mean it's when you get your services. The client could have their services before then and already have started on them, but this is when the services become an order of the court. The status hearing is different from the other hearings in that it really only has two purposes. There are some other things that are listed in the statute, but it specifically says that it's got two primary focuses. One, to make sure that everybody's been served, everybody that any guardian or parent of the child or alleged parent, that they're served and that they're aware of the case. That's something that the court has to do, and the status hearing is to find out if that's been done, and if not, what steps are being taken to see that that is done. But if your client is located and especially if your client's the one that the child was removed from, the important part is the status hearing. I'm going to talk about some things that are in the statute, some things to be aware of. One is the child and each parent or alleged parent has supplied all the information to locate an absent father, alleged father, or relative of the child. That is one of the requirements or one of the things that the court is supposed to ascertain at the status hearing. Relatives, while they don't have a right to be served, they're not a party in the case, they do have a right to be given notice of a removal and of hearings, depending on the relationship, the type of relative. And so that's something you want to look into. Hopefully you've already spoken with your client if you're representing the parents to determine if there is a relative, or if you're representing the child, that you've spoken to your child or the parents to see if there is a relative placement, so that if the child is out of foster home, you can get the child out of the foster home and into a family placement. Now, getting into the meat of this, the court needs to make sure that the parents have read, understand, and signed their service plans. The service plans become an order of the court, and this relates to one of the grounds for termination, which I talk about in the video on grounds for termination. The service plan is supposed to be tailored to the individual parent to provide the services that are necessary for the child to go home to the parent. Now, that's not always done, and a lot of times it's just the same services over and over again. The worker is supposed to meet with the parent and in developing the service plan, and to give the parent an opportunity to have input. So you should have met with your client beforehand, talk to them about the services, what services are likely to be offered, what services the parent thinks they might need. And if there are services that CPS is likely to ask for that the parent doesn't want to do, well, try to ascertain if there's a good reason for the parent not want to do it. A lot of these things, a lot of parents will consider a hassle. They just don't want to do it because they don't want to do it. Well, that's not going to get you very far in court. But there may be other reasons, and the services may not really go to your client. Why are they going to do a drug and alcohol assessment if your client has never had a history of drug and alcohol abuse? Now, CPS is going to want that because they're going to want to verify that there's not a concern there, but doesn't mean that they're necessarily entitled to it. The parent is asked to sign the service plan once it's done. Now, what the parent is signing is that they have read it and they understand it. There are sometimes some things mentioned in the service plans that the parent does not agree to, or they don't agree they happened, or things like that, or they don't agree that they have a problem necessarily with whatever it is that the department is saying that they have an issue with. So sometimes parents don't want to sign because they feel like they're agreeing to that. Just make it clear that they're signing, saying that they have received it and they understand it, and that they understand that failure to complete those services could lead to termination. That's something the court will remind them of, not only at the status hearing, but at every permanency hearing after that. The court is to review the service plan, and the court can modify it. The department doesn't get the final say. So if you think that there would be more services that would be beneficial to your client, and your client is willing to do them, ask for them. And if there are services that are going to get in the way of their job or something like that, look for alternatives. See if online courses are available. See if weekend appointments are available or after hours. The department should look into that and see if those are options. So make sure that they do. The parent has a right to comment on it. So they have a right to tell the judge if they have something they want to say about the service plan. Hopefully, if you're the parent's attorney, you've spoken with the parents and you've gone over that and you know what they want to say, and then you'll help them present it in the best way possible. If your client has not submitted a child placement form or child caregiver resource form by this point, the court is supposed to order them to complete one. You should make sure they complete one of those. If the child's not with a family member, they're going to want to get the child with a family member in most cases as soon as possible. But it doesn't have to be a family member either. It can be what they call fictive kin, a friend of the family. There's lots of families that have someone who's not a blood relative, but they're like an uncle or an aunt to the kids. They've been around so much that it's like they're a relative. Well, those people are considered as well as possible placement. Remember, the focus is what's best for the child. And it's not necessarily best to place child with a relative they don't know over somebody who's not a blood relative but has been like a relative their entire life. So make sure you examine all those options and that you're ready to ask for them if you're the parent's attorney or the child's attorney. Obviously, the child's attorney should be looking at the best placement for the child as well, and with the child's interest coming first, not the parent's. And so you want to look into those options as well. Hopefully you've spoken to the parents, if their attorneys approve that, to find out about relatives. And if their attorneys, for one reason or another, don't want you, the ad litem, talking to their clients, which will happen a lot if there's a companion criminal case, then you can ask their attorney, hey, can you ask them, can you find out for me if there's any relatives they want us to look into, and I'll help you look into them. One thing that will happen at the status hearing that should have happened at the adversary and will happen at every hearing is asking about Native American heritage. So if you haven't by now, make sure you go over that with your client and you provide the relevant information. Those are the two issues. Returning the child home is not an issue for a status hearing. And like any other hearing, if you want an issue heard before a court, you have to file a motion and you have to give notice. So if you're looking at asking for anything that's outside of the status hearing requirements in the statute, file a motion ahead of time and ask for a hearing. Now, depending on the court, they may want to set that at a different time, or they may want to set it at the status hearing. But you have to get a motion filed and you have to give every side a minimum 3-day notice. And I have certainly gotten issues off the table by pointing out that they had not filed a motion and given notice. And so if you want that, you have to do those things, so make sure you do. If for some reason you feel like the child is ready to go home now, or your client's done something that makes the house safe, or if new information has come up showing that there wasn't the danger that they thought there was, hopefully you've talked to CPS and they're in agreement. But if they're not and you want a hearing in front of the judge, then make sure you file that motion. That is the status hearing in a nutshell. Make sure you look through the statute and be ready for it. And make sure, if you're an attorney representing the parents, that your client understands what a status hearing is and what it isn't. It's not an opportunity to relitigate the adversary hearing, as sometimes parents will like to do. It's not a hearing to put the department on trial because they haven't followed their policies. Now, obviously, if they haven't done the things that are required in the status hearing statute, those are issues for the status hearing. But other things, what the investigator may or may not have done, that may have come up in the adversary hearing, but you can't relitigate that at the status hearing. Make sure your clients understand that and that they know what to expect from all hearings, including the status hearing. After the status hearing, the hearings are pretty much the same unless there's a special issue that comes up that needs to be heard, or you have a contested monitored return hearing. Of course, in those cases, you're going to sit down with your client and go over and prepare for those hearings. But the status hearing is in the statute. Make sure you look it up and make sure that you have addressed all the issues and that you come prepared to talk about the service plan, and make sure the service plan is not a surprise on your client. Sometimes CPS will file those the day before. Say, no, I want more time. That's absurd. I don't have time to meet with my client and go over the service plan in any meaningful way. Make the department do their job and make sure your client is reviewing and familiar with the service plan. And if there are any concerns or any objections, the opportunity to raise them is given to your client. Thank you again for tuning in, and I will see you next time.